Welcome, everybody, to today's quarterly National PrEP webinar. We are joined today by Joe Young, formerly of Disability Rights New Jersey, and he is going to be presenting the role of CRIPA in monitoring public psychiatric hospitals. Next slide, please. And I guess I should mention, I am Dawn Reinhardt-Wood from Rutgers University, Department of Psychiatric Rehabilitation and Counseling. I'm also joined by my colleague, Jen Sperduto, today listed as Rutgers Spree, also from the Department of Psychiatric Rehabilitation and Counseling. And we are part of the Institute for Inpatient Psychiatric Rehabilitation. This is an interactive training, and we encourage you to ask questions and participate throughout the session. A recording of this webinar will be available after the presentation at the Rutgers SHPRI website, which is listed on the screen. Just a disclaimer that the Psychiatric Rehabilitation Educational Program, or PrEP, is an online forum for a variety of topics relevant to state psychiatric hospital staff. While Rutgers and DBHS are co-sponsors of this program, the PrEP webinars are peer presented, and as such, content is independently developed by the presenters each month. So the views and opinions expressed in this program are those of the speakers and do not necessarily reflect the views or positions of any of the entities they represent. Next slide, please. And please note, we are recording this, and it will be available at a later time on our YouTube channel and through our website. So I get the honor today of introducing today's presenter. Joe is the former Executive Director of Disability Rights New Jersey. He began working with individuals and representing them with mental illness in 1979 when he joined the Community Health Law Project. He has appeared in administrative, trial, and appellate courts, including the New Jersey Supreme Court and the United States Court of Appeals for the Third Circuit. Joe has a bachelor's from Kalamazoo College and a master's and JD, Juris Doctorate, from Rutgers University. He participated in foreign study at University College, Nairobi. And with that, I'd like to turn the presentation over to Joe.
Thank you, Dawn. I appreciate the introduction. And what the purpose of this program today is to introduce you to, or give you an overall brief introduction to one of the monitoring sources of the public psychiatric hospitals. Public psychiatric hospitals are monitored by a variety of different agencies, and the authorities, the rules, the process, the remedies varies depending upon the agency. This webinar focuses on the Civil Rights of Individualized Persons Act and the way the United States Department of Justice enforces the federal and statutory rights of persons in public facilities, including psychiatric hospitals. Next slide, please. At the conclusion, hopefully you'll understand a little bit more about the outlines of the CRIPA program, be able to identify potential violations of the federal civil and statutory rights, and differentiate the roles of different monitoring agencies. Next slide. There we go. So I'm a retired attorney who represented people with disabilities. So my focus and my viewpoint and my perspective is always from the point of view of a patient advocate. So in law, there are very few black and whites. Everything is pretty much a very much shade of gray. So occasionally when I present my opinions, it will be, there are no doubt people will have differing opinions, and all opinions at some point get to be validated, depending on what judge you get in front of or what court you're at. But when we're talking about the history of people with psychiatric disabilities, there has been a progression, and we're talking about now from the 1100s on, quite frankly. There has been a shift in the responsibility of how people with mental illness and developmental disabilities have been treated. And I'm using England as a background, because most of our law comes from England. When we separated and established our new constitution in 1789, the federal government and most of the states, including the state of New Jersey, adopted as common law the law that existed in England at the time of adoption. We gradually started writing our own laws. But initially, a person with disabilities was handled by the family, usually an extended family, but it was basically the responsibility of the family. As the years progressed and people began to organize in community groups, small towns, shires, whatever, then the community became kind of the custodian, the person with disabilities. People would help generally. And then ultimately the king took over, the sovereign took over and became the ward. So when we hear ward of the court or whatever, it was initially the ward of the sovereign, the ward of the king. So for a person living in a village with mental illness, who could not make decisions or survive on their own, the king would say, okay, I'll be responsible for that person. And here's some money for you to help you. I'm hiring you in the community, you as an individual or you as a group in the community, to then take care of this person. But in the meantime, the king took all the rest of the person's money if they had any. But ultimately, it was the sovereign who became responsible. And then we started moving to institutions. When it became larger groups, then we started moving people to institutions with the belief that people in institutions have a better care. The initial institutions were set up to provide, because they would provide more humane care to people than they're receiving in the community. Then ultimately, as the institutions grew, we get these stories about the institutions becoming worse and worse. The picture there is a picture of Bethlehem Hospital, which became known as Bedlam Hospital in England, which of course is where we get the word Bedlam from because of all the bad stories that came out about Bedlam. The Bedlam Hospital was founded in 1247. The first hospital, the hospital in Les Mis, which I think those of you who enjoy the Broadway show, that hospital scene, it takes place in around 1835. The first psych hospital in the United States was in Virginia in 1773. Next slide, please. So we have people living in institutions, but by what right does the state or the government have to keep somebody in an institution? Isn't our inherent right to be free, pursue liberty and all that kind of stuff? So, but the response is that there are two ways that the state has the authority, the legal right to hold somebody against their will. The first right is what's known as parens patriae, which means father of the country or parent of the country, which is what I had said before. The king had took over the responsibility for the care of people with disabilities who could not take care of themselves. So the right of the king to involuntarily detain or to move people where they want is the parens patriae. So if somebody is unable to care for themselves, then the parens patriae, the jurisdiction of the state, to then assume responsibility for that individual and basically to confine them if they need to be confined or to provide treatment if they need to provide treatment. The other authority is the inherent police power of the state, the need of the state to maintain order. So the Oaks thing, which is the parens patriae power, is the first reported case that I can find in the United States of somebody who is in a psychiatric institution trying to get out. And the court then saying, no, because you need our assistance, we get to keep you in a hospital for the time being. The Jacobson case, which says that the state has the authority to protect all its citizens, it actually involves a vaccine case in Massachusetts in 1905. The Commonwealth of Massachusetts had said that if a local municipality decided there was a health crisis in their town, they could require people within the community to take a vaccine. Jacobson said, no, I'm not going to. He was arrested because not doing it at the time was a crime. And the the United States government, the Supreme Court, held in 1905 that based on the police power of the United States, police power of the government, that Jacobson could be required to take a vaccine if there was a legal authority determined that there was a health emergency. So those are the two reasons people we get to move people into institutions. Next slide, please. The rights of the people in institutions, however, were very slow to develop and started developing pretty much on a state by state basis. There was no federal oversight, no general federal law on mental health until much later. The first New Jersey case that I was able to find was in 1912, where a guy was kept at Trenton. And the problem there was that the New Jersey law at the time said that if somebody filed a petition to move somebody into saying that they needed to go to the state hospital, they could be picked up by the authority and taken to the state hospital for 15 days. And then within that 15 days, if the individual asked, the local authority could conduct an investigation as to whether or not he needed to stay. Well, what happened to Mr. Al Gore is before the 15 days was up, somebody filed another petition. So if they kept filing petitions, Mr. Al Gore never would have had a chance to have the reason he was being kept there investigated. So the New Jersey State Court said in 1912, you can't do that. At some point, there has to be some kind of judicial hearing as to whether or not the person needs to be kept in the hospital. And that was pretty much the situation for a long time. It was easy to get into the hospital. People were taken to the hospitals by family members or the community and taken there, and they could only get out if they petitioned the court with what's called a writ of habeas corpus, a writ to the judge, a request to the judge to say, look, I'm here, I don't belong here, I want to leave. And then in most states by this time, the person was entitled to a trial as to whether or not they needed to be kept in the institution. In a lot of states, it was in fact a jury trial. It could be 6, 8, or 12 people would have a trial to determine whether or not they believed the person needed to stay in the facility. But the person had to be there first and then asked to get out. Was pretty much the way the situation existed for a very long time. Next slide. In 1868, following the Civil War, we passed a series of amendments, the 13th, 14th, and 15th Amendments, in response to the Civil War. And part of the first section of the 14th Amendment has the famous Due Process Clause, which says that no state shall deprive any person of liberty without due process of law. Now, this was passed in 1868. It wasn't applied, and this would be the federal statute on which CRIPA is based. This is where almost all the constitutional rights of people in psychiatric hospitals are derived from this very short line in the 14th Amendment, which was intended actually to deal with Civil War issues, not with people in mental illness. Most states had something that in the Fifth Amendment to the Constitution, there's a similar due process clause, but that's only a clause that applies to the federal government. It says the federal government can't deprive any person of life, liberty, or property without due process. It's not till the 14th Amendment in 1868 where the federal Constitution now applies this to all the states. Next slide. But it's not till the 1970s, again, another 100 years later, that we begin to apply the federal Constitution to the rights of persons with mental illness in psychiatric hospitals. So it's not until 1979 in Addington versus Texas that established that if the state wants to keep somebody in the hospital, then the state has to prove by clear and convincing evidence that the person needs to stay there. When I was talking about the trial by jury about whether or not somebody was allowed out on a writ of habeas corpus, basically the person in the hospital had to prove that they should be let out. Now we're switching the burden of proof now to the state. If the state wants to put somebody in a hospital and keep somebody in the hospital, the state now has the responsibility to prove by clear and convincing evidence that the person needs to stay there. Clear and convincing evidence is a middle ground burden of proof. We're all familiar with beyond a reasonable doubt, which is the criminal standard, and preponderance of the evidence, which means like 51%, is the general standard for basic civil cases. Do I owe you money? Do you owe me money? Those kinds of cases are just a preponderance of the evidence. So clear and convincing is a higher standard. If you're taking away somebody's liberty, generally, or somebody's rights, then the general rule is that it has to be by clear and convincing evidence. And it's not to the following year in 1980 that we finally have the rules on which commitment hearings are held. In Vitek v. Jones, the United States Supreme Court set forth finally the rules of how a proceeding is supposed to be held. Up until this time, states were doing things their own way and had a variety of different protections for people who were at risk of being put into a psychiatric hospital. So in Vitek v. Jones, we finally have the United States Supreme Court saying that if you're going to commit somebody, you have to give them prior notice of the intention to commit them. You have to disclose to them the evidence that you're planning to use. They have to have the opportunity to present their own witnesses, to testify themselves, and to confront the witnesses that are being presented against them. Different from the Vitek does not require that it be a judicial proceeding. Vitek only requires a neutral decision maker. However, all the states, I believe at this point, have a judicial proceeding, and it's the judge. It's a judicial proceeding. Independent assistance is, again, the Supreme Court, it did not require that an attorney be appointed for the individual. They say the Constitution only requires that the individual receive independent assistance. Again, however, I think most states require the appointment of a counsel. They've gone beyond the bare constitutional right. And then again, obviously did this slide late at night, requires a written decision that if you're going to do it to the person, you have to put in writing the reasons for your decision. Next slide. So this is maybe a place to stop to see if that's been confusing enough for anybody, or if there are any questions at this point. So what we've set up is the starting of constitutional rights, federal rights for people in psych hospitals by virtue of the fact that their liberty is being deprived when they are kept in the psych hospitals involuntarily. So we have the process, we have the standard of proof, and we have information about how the hearings are supposed to be held. But what we don't know yet is once the person's in the hospital, what are their rights? If they're being kept in a hospital, do they have a right to actually get treatment while they're in the facility? And the first effort to answer this question was done in Alabama. A case was filed against the hospitals in Alabama, Wyatt v. Stickney, in the early 1970s, where the people in the hospitals there claimed that their constitutional rights were being violated because they weren't getting treatment, or the treatment they were getting was not all that great. The standards in the facilities weren't really terrific. There was a shortage of staff, well, a whole variety of things. And the judge in that case, ultimately, because the parties couldn't agree, wrote a 13-page appendix with a list of all the constitutional rights that somebody in a psych hospital would get. And some of these you're familiar with right to wear clothing, the right to have visitors, the right to exercise, and then a whole list of staffing things and individual treatment plans, a variety of stuff like that. So it's 13 pages worth of stuff that this particular judge felt that people who were involuntarily to a state institution had a constitutional right to treatment that would afford them a realistic opportunity to return to society, and he listed out 13 pages of what that would require. The first chance for the United States Supreme Court to answer whether there was a constitutional right to treatment was in O'Connor versus Donaldson. This is a case out of Pennsylvania, where a gentleman was kept in a psychiatric hospital for 15 years and basically received no treatment during that 15 years. Basically only received custodial treatment. He received pretty much no mental health treatment. Now, he refused it, and they said fine, and just kept him there without providing any services at all. And at trial, it was determined, in fact, that he may not even had a mental illness at the time of the trial. But in Connor versus Donaldson, the only thing that the court held was that a finding of mental illness alone was not enough to keep somebody in an institution against their will, and just providing custodial treatment. The court didn't answer the whole question about what else in addition to a mental illness was necessary to keep somebody in the hospital. But just because somebody has a mental illness is not constitutionally sufficient to keep them in a psychiatric hospital. New Jersey answered the question before any of the other states and said that in State v. Kroll, which should be a familiar name to most people, that mental illness plus dangerousness was required in New Jersey. So somebody in New Jersey who had a mental illness could be kept in a psych hospital if they also met the requirement of being dangerous to self or others. Next slide. All right. I don't know how many people can read that. So let me do. So the case that finally said that there's a constitutional right to treatment, or answered the question how much of a constitutional right to treatment there is Youngberg versus Romeo. Now, one of the problems with Youngberg is it's actually a case that involves a facility for persons with intellectual disabilities. So mental illness was not directly addressed in that particular directly, because it talks a lot about training rather than treatment in the Youngberg case. But Youngberg decided that, first of all, in the Youngberg case, the state conceded, the state of Pennsylvania said, we agree that there's a constitutional right to adequate food, shelter, and clothing, and medical care. So if somebody's in a psychiatric hospital, there's a federal constitutional right to adequate food, clothing, and shelter, and medical care. There's also a constitutional right to reasonably safe conditions of confinement, freedom from unreasonable bodily restraints, and such training as may be required by these interests. All right. So, and this is it. This is the sum and substance at the moment of the federal constitutional rights, the treatment and protection from harm in state constitutional in the U.S. Constitution. And it's from these three phrases that all these other, that the monitoring that's going on in the findings of the U.S. Department of Justice come from. So it's based on, first of all, freedom from unreasonably bodily restraint. So the first thing, it was clear that this is the most objective standard that the court was able to set up. If you're going to keep somebody in a psychiatric hospital, you can't keep them restrained unreasonably, right? And so that's kind of an objective standard almost, that you can count the number of times somebody's been restrained or the hours they've been restrained. If it seems like a lot, then the restraints may be unreasonable and they may not be getting the constitutionally required treatment to keep them from being unnecessarily restrained. And such training as may be required. So again, so it's a minimal standard which says, in order to the constitutional requirement is that they have reasonably safe conditions, they cannot be restrained unreasonably, and they have to get enough training to make the likelihood of, to reduce the likelihood of treatment of restraint. And that's kind of it from the constitutional standpoint. The court did not agree with Judge Johnson in Stickney about the 13 pages of rights that he found. But a lot of the states adopted some version of Judge Stickney's 13-page appendix, and the rights patient rights that are in New Jersey statute are in fact pretty much copied from Judge Johnson's Wyatt opinion. So while those are no longer constitutional rights, that whole very long specific list of constitutional rights, but they now are state statutory rights. And enforced in a different way. And then the caveat of all of this, because the United States Supreme Court said, we're attorneys, we're not doctors, so we can't make treatment decisions. So we're going to say that all these three prior conditions depend on the treating professionals operating in professionally appropriate standards. So decisions made by the appropriate professionals are entitled to the presumption of correctness. Right? Next slide. So after the court had decided Youngberg, the United States Attorney's Office, U.S. Attorney's Office, Department of Justice attempted to bring suit in a variety of states, a couple different states, where they felt there were really bad conditions in the hospitals. And in those instances, the court said no. That the U.S. attorney doesn't have the automatic right, the inherent authority to go into a state and sue a state hospital for constitutional rights. The patients can do that. Parents or friends on behalf of the patients can do that. But the U.S. attorney's office does not have that authority. So the U.S. attorney went to Congress and said, look, things are happening in the states that we don't like, that we think are problems, that we want the authority to go in and take care of these issues. And this is where the Civil Rights of Institutionalized Persons Act was enacted in the late 80s. And this says, the CRIPA says, that whenever the Attorney General has reasonable cause to believe that any state or public division of a state, official or employee, is subjecting persons residing in or confined to an institution to have engaged in egregious or flagrant conditions which deprive such person of any rights, privileges, or immunities secured or protected by the Constitution, causing them to suffer grievous harm. So all these highlighted cases are legal issues, legal phrases that everybody gets to argue about. But basically, the jurisdiction is available only in pattern and practice cases, cases where a large group of individuals is suffering egregious or flagrant harm, grievous harm, egregious or flagrant conditions, and pattern of practice. So an individual with who complains that they couldn't go outside on Tuesday clearly doesn't have the authority. The U.S. court doesn't have the authority to go in there. But if there is a situation where the U.S. attorney alleges that there's a hospital where 30 or 40 people are being restrained unnecessarily on a regular basis, that is an argument. That's the jurisdiction that they would have to go in there. So it only applies to public facilities, and it applies to more than just state psychiatric hospitals. It applies to any state institutional state facility where people are involuntarily held, including prisons, nursing homes, and developmental centers, in addition to psych hospitals. And the relief they get is equitable relief. The relief they get is an order to do better. An order that they don't get a fine, people aren't put in jail. There is no monetary award. What they get is an order from the judge or that these are the things the hospital has to do to get better. All right, next slide. Any questions at this point? Go on. See, nothing, we're good. All right.
No, we're good.
All right. Yeah, because it's a little dense subject at this point. So those of you who work in hospitals must feel that you're being monitored or reviewed or somebody's looking over your shoulder all the time, because there are lots of different people in the hospitals conducting what may be called monitoring. or advocacy kind of work. The Department of Justice are the really big guys that do the really bad looking stuff. So something hits the paper and sounds really bad, deaths here or restraints there or suicides or whatever it may be. That's DOJ, the Department of Justice, but they can only enforce rights under the Constitution and federal statute. So they have big guns, but limited jurisdiction, and they can only do systemic complaints, the complaints that involve pattern of practice and a large number of people. CMS, the Center for Medicaid and Medicare Services, and the Joint Commission do a different kind of thing. First, they do the accrediting thing, but then they do the periodic surveys once every 2 or 3 years. They come in and follow either the state operations manual, which is CMS, or the Joint Commission's own standards, and do a survey, walk through the hospital, conduct their reviews to monitor to see whether or not the hospital is complying with the standards that are set out in their compliance manuals. The protection and advocacy programs, which are in each state and every institution, they're the ones that can do individual cases. All right, somebody calls up the protection and advocacy program in New Jersey, it's Disability Rights New Jersey, and says, I haven't been able to go outside for fresh air for the last week. Then the P&A can go in and investigate whether or not that particular individual's fresh air rights are being met. In addition, whether or not there may be a problem in that particular ward or in that hospital with the patients getting their right to fresh air, as in the patient's New Jersey Patients' Bill of Rights. The P&A can look after both federal rights and state rights in both statute and administrative codes, and can represent individuals in court. So the DOJ is going to go to court. CMS and Joint Commission are not going to go to court. They're going to provide you with assistance to correct the facilities and bring them back up to the standards. Really bad instances, they may withdraw accreditation. The state agency sometimes acts as a look behind, both for sometimes the feds will get a complaint and they'll ask the state agency to do an investigation. The Department of Health, I think, in New Jersey. And also there may be a survey on the survey results. The state will state licensing agency will go back and make sure that the hospital has complied with the things, make the improvements that were found in the survey. All right, next slide.
Joe, we do have one question before you go much further. It was about your previous slide and how you described CRIPA as making recommendations to the organizations to do better. And the question was, what does better mean?
Right. So I think the next slide may answer that question. Yes. So this is how CRIPA goes. This is how CRIPA goes about the process. Usually there's something that hits the newspaper. There's usually some big event, some hospital, or there'll be a patient, a family group that will complain either to the local U.S. attorney in that particular state or that judicial district, or directly to the Department of Justice. They'll do a little behind the scenes investigation. And then if they think there's something there, they'll send a formal notice to the state saying that we're going to conduct investigation in your facility and we'll be there on Tuesday. And then there's a whole negotiation process with the state about when they get in, how much they get to see, all that kind of stuff. But eventually there's an on-site investigation where the U.S. Department of Justice, who are again attorneys, will bring in expert consultants in the field to start looking at the complaints were made. And basically, once they get in, they start looking at everything. But they'll bring in their own experts in psychiatry, psychology, discharge planning, psychiatric nursing, suicide prevention, protection from harm. They'll interview administrative staff, mental health providers, and the patients. They'll also do a physical inspection of the plant, we look at records, policies and procedures, and incident reports. So basically the whole hospital is up for grabs. The on-site process usually doesn't take much more than a week. And at the end of the week, there's an on-site debriefing. Basically said, we found these things, and if you work on this kind of stuff, but we suggest you start working on this stuff now, and we'll come back with our formal report later. The formal report is called a findings letter. It's required by the statute before the department can sue the state for violating people's rights. They have to send the state a letter with their findings and then their suggestions for doing better. And that's the doing better part. It's you can't see it here, but on this particular letter, it's recommendations for remedial measures. So they'll basically say, we found that your treatment plans were incomplete. So their suggestion for doing better is going to be make your treatment plans more complete. The recommendations that they give you at the end of the report are really very general. And what they're really looking for is this negotiation process between you and the feds on more specifically, what does doing better mean? What does making the treatment plans more complete mean? What does doing an incident investigation better really mean? So they will find in their finding letter that your incident investigation is not very good, and the recommendation will be to improve your incident review, and then you're going to work with them for 5 or 6 different steps on how to make incident reviews better. I have an example coming up, I think. Next slide. All right, so Jersey has CRIPA has been in New Jersey. Not all in psychiatric hospitals, but the Mercer County Geriatric Center in 2000, there were complaints about the grossly unsanitary conditions in the Mercer County Center. New Lisbon was in 2004. One of the reasons there's a complaint about restraints it started off with, and they went in and found that everybody had exactly the same treatment plan. Woodbridge Developmental Center, where, again, there was a complaint about treatment plans and I think restraints. In Cora Psychiatric Hospital, there were a variety of different complaints, but the main complaint in Cora was about people that needed to be discharged but were kept in the psychiatric hospitals. The Edna McMahon Corrections Facility, it's been in the news for the last 2 or 3 years now. It's the Women's Corrections Facility where there were allegations of sexual abuse by the guards. The Cumberland County Jail is the allegation there was a variety of suicides in the Cumberland County Jail. And just within the last couple of weeks is the New Jersey Veterans Memorial Homes investigation with all the deaths that took place as part of COVID. So these are prior instances where CRIPA action has been taking place in New Jersey involving a variety of different facilities. Next slide. For purposes of this review, we looked at 15 different findings letters from Connecticut, Oregon, Georgia, New Jersey, and Delaware. And quite frankly, at some point, they all read the same. They find the same thing because the findings are limited as to the general category of what the feds can find. So the next slide, I'll show you this. Next slide. All right. So again, as I said, the feds can come in and only their jurisdiction is limited to the things I said in Youngberg, reasonable conditions of confinement to reduce the restraints. The Americans with Disabilities Act, the Olmstead thing. So Olmstead is now, I think, is going to be the new major focus point for the CRIPA investigators to get people out of institutions and into the community. And Cora was heavily, that's what they looked at heavily in that particular letter, because over half the people in Cora at the time were on condition extended pending placement. They had been found not to need continued confinement in the state psychiatric hospitals, but were still there. So when over half the hospital population could be living in the community, the feds are going to come in. And I think that's going to be the new focus or the primary focus now for most of their CRIPA investigations. Civil Rights Act of 64, there were two instances in these findings letters. One where patients with limited English proficiency were not provided appropriate accommodations for their limited English proficiency. And then the deaf community in one facility was not provided appropriate treatment to accommodate their deafness. Title 18 and 19 of the Social Security Act are the conditions of participation. They're only going to be secondary reasons that the feds are going to come in. They're going to say this is a constitutional violation, and also, by the way, you're not meeting your standards of participation under Titles 18 and 19 of the Medicaid Act. Next slide. So the major findings when they go in to an institution, the things that they will find is a failure to protect patients from harm, a failure to provide appropriate mental health treatment, inappropriate use of seclusion and restraint, and failure to provide adequate medical care. Now, these are obviously large subjects. These are the giant subjects from which additional findings are found. Next slide. So in the category of failure to protect patients from harm, again, there's been a failure. The findings have found when they've gone on failure to provide adequate food, clothing, and shelter. Suicidal ideation attempts are not addressed appropriately. So in one situation, one hospital had a 12-page assessment, admissions assessment, to determine whether or not somebody was at risk of self-harm or suicide attempt. They found when they went in there that the facility, as the persons administering the assessment, for the most part, ignored the 12 pages and pretty much asked only, are you planning to hurt yourself? And regardless of the answer, it was just put in the file and there was no response to it. So that's a clear indication in that particular instance that suicidal ideation and attempts were not being adequately addressed. They weren't being assessed. And then if they were found, there was no plan to deal with them. And then there was no monitoring afterwards. And that's pretty much the standard. Anything when they find something wrong, it's pretty much based on an inadequate assessment, an inadequate response to the assessment, and then inadequate follow-up, inadequate data collection, and then inadequate follow-up. So for each finding, pretty much this is the rubric that goes through, and this is pretty much they can document in each one of these instances. Inadequate incident and risk management, for example. So in Ancora, they found that there was an incident review team that met, and pretty much all they did was they were told how many incidents of self-harm or patient assault there were, and did not review any of the particular instances. They didn't review any particular instances or didn't review any trends regarding those incidents. And in fact, the incident investigations themselves very seldom, if ever, interviewed the patient who may have been the subject of an assault or the perpetrator of assault. The perpetrator was almost never interviewed on any incident investigation. Same thing with inadequate quality inadequate quality assurance. So you take the individual incidents and then you aggregate them and then you look at quality assurance. So again, in a lot of instances, there just isn't adequate data collection to be able to do any quality assurance, or that the quality assurance measures are not standardized across units. One instance, there's a hospital reported, I believe, incidents of restraint, hours of restraint, to a national organization using one standard and use totally different standards on their units. So there's no way to do good data management, collection, and assessment. Next slide.
We did have a question come in, Joe.
Sure.
Some patients are difficult to discharge because of history and end up back in the hospital. What is the remedy for that?
Right. So we're going to get to that in a second. But their answer they're going to give you is that you have to have a behavioral plan for people who are resistant to discharge and people who are readmission. So again, you have to do your, again, and I'm probably using it wrong, you have to do your behavioral analysis. Why is this for this particular individual? And then respond by having a behavioral treatment plan that will respond to that. Again, this is obviously not an easy task. What they're saying is if you have identified a group that you can't discharge, a comorbid medical situation, a resistant to discharge, and maybe in Jersey it was dual diagnosed group, all right? Then you have to make plans, individual and group plans for that group. You just can't say this person's resistant and then have no specific plan to deal with the resistance. Next slide. All right, so the other one are failure to provide appropriate mental health treatment. Psychiatric assessments and diagnoses are inadequate. The big thing that they're looking for, treatment plans are not individualized or patient-centered and do not address patient needs. They're looking in a lot of instances for, in fact, interdisciplinary input to the treatment plans. A lot of criticism for situations where the psychologist doesn't show up, or the nursing staff is not represented, or even the HSTs are not represented in developing a treatment plan. Again, failure to address repeated admissions. What are the antecedent conditions that cause the person to have repeated admissions? Is the substance abuse services appropriate? Behavioral services are not timely. Again, there's another instance of somebody who was engaging in self-harm, right? So they did a behavioral analysis, and there was a recommendation 15 days after the last, after the request for analysis was requested, a behavior analysis was done, a recommendation was made and never implemented. Behavioral plans are not modified appropriately if they don't work, and behavioral plans substantially depart from generally accepted professional standards. Now so this line about generally accepted professional standards is the out for the institution. The institution would say, look, we're doing this, our behavioral plans meet their generally accepted behavioral standards. And so that may be a defense, but then if the behavioral plans are not working, then you've got to modify them, right? And if you don't modify them, they're not working, then again, they won't meet generally accepted standards because they have to be modified. But generally accepted standards is the phrase that they use to say that you're not doing what you're supposed to do. And at the end, in your at the end, when you do the assessment of the workshop, there's a handout where I've given you selected instances of what generally accepted professional standards means in a couple of cases. What it means in developing a treatment plan and what it means in a few other instances. Next slide. Inappropriate use of seclusion and restraint. Now, seclusion and restraint is the last resort, always the last resort. It can't be used for the convenience of the staff and for disciplinary reasons and a variety of other things like that. There's one particular instance of a facility that the feds found that an individual was yelling and refused to stop yelling and was put in restraints. Well, there was no imminent self-harm to anybody. There was no imminent harm to him or anybody else. He was yelling and he wouldn't stop yelling. So putting somebody in restraints for yelling, even when you can't get them to calm down, is a constitutional violation. It's an unnecessary use of seclusion, inappropriate use of seclusion and restraints. All right. Next slide. Medical care. Again, so when they look at medical care, they're going to look at clinical oversight, whether basic medical care is available. In some instances, there was not monitoring for things like fecal impaction, diabetes, pica, things like that. Pharmaceutical practices are inappropriate. A variety of instances, they found nursing staff signing the sheet that medication had been administered before it was administered, and then finding in some instances that it wasn't inadequate infection control, inadequate physical and nutritional management, inadequate emergency preparation, and inadequate staffing and nursing services. They found in one instance, the head of the psychology staff had 115 cases, for example. So even with 115, which was an overload for an individual, there's absolutely no way that person could also do supervision. All right. So I'm racing through this because I thought I would have a lot of extra time to go in more detail, and I'm finding I have a lot less time to go into any detail. Next slide, please. And that's why I'm afraid it's a little hurried and jumbled. All right. So Olmsted is the next one. That's the one about trying to get people out of the hospital. Right. Where people try to get people out of the hospital, where you have to plan people with disabilities have a right to be in the community and to interact with non-disabled persons to the fullest extent possible. So I know when I was in New Jersey, there was a group of people that were resistant to discharge. And so they were moved to a facility, a house, group home, right off the grounds of the hospital. But basically had no interaction with the community. So while the group home itself was being administered by a community agency, there was very little interaction with the community itself. So the goal here is to have people move out, and I appreciate that there are difficulties with that. But again, the person has to have a plan to overcome the difficulties, and the plan has to be evaluated and monitored as necessary. The person gets to move out of the facility if the professionals determine that the community living is appropriate. And in New Jersey, it's easy because the person's on CEPP status, then that's already been determined. If the person themselves does not oppose treatment. Now, if the person does not oppose treatment, you can't go in under Olmsted and move them out, but they do not have a right under Olmsted to stay. So the state can say, we're not keeping you in an institution if you don't need to be there. You do not have a constitutional right to stay in an institution if you don't need to be there. Then the problem is the placement can be reasonably accommodated. And that's a sticker. Obviously, is the state providing enough funds? And part of the suits that have gone on, and the suit that we brought in New Jersey was to require the state to start providing enough funds to start moving people out. So I believe we reduced the CEP population from over 50% down to closer to 30%, and the average stay of from 2 years on CEP status to something more like 9 months. So there's got to be a requirement to try to keep moving people out and plans to do that. Next, please. I think I'm very close to the end. Can take questions.
We did have one more quick question.
Sure.
Could you, unless you want to hold it to the end, Joe?
Go ahead.
Could you speak to the tension between one patient's right to have minimal, oops, my chat just moved up, hold on. To have minimal restraint and seclusion, and the right of other patients to be protected from harm if that one patient is consistently violent?
Right. So that's the plan, right? You have to develop that plan. If the person is at that moment an imminent risk to himself of harm or to others of harm, then there can be a restraint or a seclusion plan. Again, you've got to move from the step up. You've got to take the least invasive step first. Right. So when you consider that, when you do that, you have to do these considerations. You have to, and then after there is a tension. You do have to protect the patients. That's why staffing levels may have to be appropriate. That's why one-on-one or line of sight supervision may be needed to anticipate a problem and intervene earlier. All those things are the feds are not going to say this is what you needed to do in this situation. The state is going to say the feds are going to say you needed to have a plan for what you're going to do in this situation. And if you know you have a person that's periodically is triggered, I know we had I don't know what the situation is in the hospitals now, but every time a person was refused to be able to use the phone, they would become agitated and threaten violence or start acting like it. So if you knew that was the antecedent, you knew it was happening, you had to have a plan to deal with that. All right. Next slide. And yes, I'm pretty sure you're getting a copy of the PowerPoint presentation. Olmstead findings, you have inadequate coordination between the community and the hospital. So I know Jersey's trying to do that with some groups, but discharge people, you've got to work. You can't discharge somebody to a community. You can't discharge somebody with a behavior plan to the community and not tell the community what the behavior plan is. One person was readmitted because they didn't have transportation to the methadone clinic. Another person was readmitted because they were on a waiting list for an appointment for the community services. You have to have better coordination. You have to have plans to deal with readmission. And then you have to look at specific populations and try to address their things. So resistance to discharge, behavioral problems, comorbid medical conditions, dual diagnosis, and a history of sexual offenses. Next slide. So the feds, there's always a tension between the feds and the community. So that you're coming in here and telling us to how to run this institution. These are the resources we have. We're doing what we think is according to standards. So it's a battle of the experts kind of tension, and the process takes too long. The example is the New Jersey veterans thing. So they came out with their findings letter last week, the week before, and the deaths happened in 2020. So there's the process may be taking too long. Once let me finish up with just the end of the process. I'm sorry. Once there is the findings letter and they said we'll sue you unless you fix this, there's usually a long period of negotiation. If they're able to reach an agreement with the state, everybody will agree to a settlement agreement, and then they'll go to the court and file the complaint and the settlement agreement at the same time. So that if the state doesn't comply with the settlement agreement, the feds can go right to court and go to the judge and say, look, they're not complying with this, order them to comply with this. These days, it usually the state will agree to hire a monitor, an independent person who will come into the hospitals and monitor the state's progress in complying with the agreement, and then also providing technical assistance to the hospitals to help them do that. I know in New Jersey that the department was very, very happy with the monitor that they hired as in some our settlement agreement, and that she provided a lot of technical assistance to them to make some improvements and improve their policies and procedures. Okay, I think that's it. We have a couple of minutes for any more questions.
Thank you, Joe. We do have a couple more questions. So one of them was, I think you somewhat addressed it, or I think you addressed it, but in as it refers to professional standards, Tom asked which professionals and who says.
Right. So the feds hire the experts, so they get to say. So in the handouts, I've given you, and unfortunately I didn't make a copy for myself at the moment that I can read from real quickly. But in the handouts I've done, it gives you quotes from their letters about accepted professional or qualified professional standards require treatment plans that are assessments that are comprehensive, include interdisciplinary support that are amended periodically. The data is collected, so they're still kind of general. And then when you get to the remedy section, when you get to the settlement agreement, they're more likely to be much more detailed, which says the team will consist of these 5 people. The treatment plans will be reviewed every 3 months. If there's a incident, 2 or more incidents within a 5-day period, the treatment plan will be reviewed then. So those kinds of things are likely to get much more specific. So in the findings letter, they get to say what accepted standards are. And at some point you can argue with them whether that, but the real discussion gets to take place on your response to fixing the problems that they found. And I might add, so in the 5 letters that I know you're interested in evidence-based practices. In the 5 findings letters, I mentioned a specific evidence-based practice is only mentioned once, right? A person with major depressive disorder it was determined that she should be getting DBT. DBT was not available in that hospital, so the staff recommended the person be discharged to another hospital. So the absence of an evidence-based practice for that individual was found to be deficient.
Thank you. Well, this will conclude our training for today. We ask you to please complete a training evaluation, excuse me, and receive a certificate of completion for your attendance today. In addition, the handouts that Joe had mentioned will also be available with at that link along with the evaluation. So Jen has put the training evaluation link in the chat. We also invite you to check out our Rutgers Institute for Inpatient Psychiatric Rehabilitation link if you haven't already done so. And with that, we thank you for attending and look forward to seeing you next month. Thank you all.